Okay, good evening, everybody. Welcome to week 10, getting ready for trials. So today our guest speaker is Jennifer. Thank you, Jennifer, for joining us. So I'm just going to go over some of our intro slides here. We'd like to just acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh Nations. And about AC Friends of the Court, we're a nonprofit organization. We began in 2011, and we currently hold a legal forms workshop, and we help clients fill out their forms. At present, approximately 45% of clients are family law clients. Just a quick acknowledgement of all the people that we would like to thank, because this would not be possible if not for their assistance. Okay, a reminder to everybody that we do not provide legal advice. So quick reminder of the difference between legal advice and legal information. So do not provide any kind of specifics about your cases when putting anything in the chat. If you have any of the questions, just make sure that they're not case specific and they're just more related to legal information. A reminder for everybody to, because this is being recorded, change your names to either your first name or just your first initial, last initial. And make sure you have your mic muted and that your video is off during the entire session. If any of your questions, just submit them in the chat box directly to the main session and not to the speaker directly. And then we'll answer all the questions at the end during our question and answer session. And just a reminder to be respectful of all the speakers, our volunteers, and staff and registrants. So our guest speaker again is Jennifer. We've already had a couple of sessions with her, so I'm sure you already know her. She's a designated paralegal and legal coach. She's been working in the field of litigation since 2013 and exclusively in family law since 2014 as a paralegal. And she is a volunteer with Amici Curie since 2016. Okay. Our outline and objectives today: understand what will be required of you on the day of trial, evaluate the usefulness of duty counsel for your matter, evaluate the usefulness of a Mackenzie friend for your days in court, understand how to make accommodation requests or request an interpreter, assess whether you need and should call an expert witness, assess the role and value of other witnesses, prepare an opening and closing statement making clear what you are asking for and why, obtaining transcripts from after hearing or trial takes place, listening to the recording of your hearing after the fact, and then we'll have our question and answer session. Okay, I'm going to pass it over to Jennifer now.
All right, thank you, Rachel. Thank you, everybody. So a little bit of a story about today that Rachel has kindly not shared, but I'm going to share instead. We actually had a different presenter who was supposed to present tonight, but unfortunately she was very, very ill and could not make it. So I am stepping in and I'm going to be doing this presentation with you all tonight. So do bear with me while I go through the material. So I have done trials before. I have done, not like I have represented somebody in trials, but I have assisted in many trials, and I've actually coached a self-represented litigant in their own trial. So I'm going to share some experiences that I've had from my point of view, what I have seen happen during trials, and I'm going to try to, sprinkle it in as I go through the slides. So basically, the first thing I want to go through is important trial deadlines. So you're going to see that there are a number of important bullet points here of what you should be expected to do before your trial. Some of these may not actually apply to you. So what I'm going to do is I want to point out the really important ones. So the important dates, or what we call limitation dates or steps to make sure your trial doesn't get bumped or struck out. So you might hear that with the registry. They like to use the words bumped and struck out, which basically means you don't have a trial. So one of the big ones is, so number 2, examination for discoveries. They should be done 60 days before the date of your trial. So examination for discoveries, it won't bump your trial if you don't do one, but they are very helpful to do because it kind of helps both parties understand where their case is at and what their positions are. So examinations for discovery, if nobody has done these before, basically what that is that you essentially, I'm going to call it interrogate. You're interrogating the other party. So what happens is the claimant and the respondent both have an opportunity to examine each other. So sometimes one party might have a lawyer, sometimes both parties might have a lawyer, and it'll be the lawyer doing the examination. So how you would do that is you would file something called an appointment for examinations to an appointment to examination for discovery. It's a form that you can find on the Supreme Court website. I would have to look up the exact form number. So basically what that is putting the other party on notice that you intend to examine them. When you're setting these, you do need to get the other party's availability because you want to make sure that they are available and present. So normally what you would do is you would ask them, okay, what is your availability? I want to set an examination for discoveries down in, April 2024. Give me your availability for that time. They would then tell you. You would then have to go book a facility. There's a few places you can use. So in my experience, we use Cortex, which is a transcription service. There's another company called Charest, West Coast Reporting. So you're using like an actual company. And what that company does is they would book a room for you. They would hire what's a transcriptionist who will transcribe the whole discovery for you. So once you've done all that, you would then serve an appointment to examine for discovery on the other party. So that is an important step that you should utilize. The next big one is number 4, trial briefs. So the rules have changed recently when it comes to when you must file and serve a trial brief. It used to be 7 days before the date of your trial management conference. They've now changed that. It is now, for the claimant, 56 days before the date of trial. So it's after you file your notice of trial. For the respondent, it's at least 49 days before the trial. So you want to make sure that you know those deadlines. So in an office setting, normally what I would do at my office is we would have a calendar and we'd put these important dates in the calendar. So what you would want to do on your own is you would want to set it up, or you want to make a note, put it in your phone, put it on a computer calendar, even a diary. If you have a diary or an agenda, you want to make sure you keep track of those dates. So the next thing you want to do is you want to make sure that you have done a trial management conference, because that is another thing. If you don't book a TMC or trial management conference, your trial can get struck or bumped. So you want to make sure that you do that, and you have to do that one within at least 28 days before the date of your trial. So no more than 28 days, no less than 14 days. Another thing that could potentially get your trial struck is if you do not file a trial record. So what a trial record is basically, it's like a summary of your case. So usually it would contain what you would call commencement pleading. So what's a commencement pleading? It's the notice of family claim. the response to family claim, the counterclaim, and the response to counterclaim. You would also include your financial statements. So if you filed financial statements, you would include your most recent financial statements. You would also include any orders that might be affected by the trial. So if anybody has gone to court before the actual trial itself, you would want to include those as well. Another thing, if you do not file before your trial, is the trial certificate. So both the trial record and the trial certificate can get filed at the same time because they have the same type of limitation date. So not more than 14 days before the date of trial, not less than 14 days for the date of trial, not more than 28 days before the date of trial. So basically, in summary, the most important besides the examination for discoveries is point number 4, your trial brief, make sure that's done. Point 5, your trial management conference, make sure you have scheduled that and you attend it. Point 8, your trial record. And point 9, your trial certificate, make sure those are filed before your trial. All right, next slide. Sitting schedule. So what's a sitting schedule? So it's basically the courts typically will have a specific schedule they go by. Trial and what you would call regular chambers. So when you would go to court for, before you have a trial, you run to court, you're like, I need to get a temporary order. So both, and that's called chambers. So both chambers and both trial, they have a sitting schedule. So for trial each day will start at 10 a.m. So if you have a 5-day trial, every day you come in, it's going to start at 10 a.m. It goes to roughly around 11:10 to 11:15. So from 10 a.m. to 11:10-ish, you will have your first part of court for the day. You will typically have a 15-minute break. After that time, after that 15-minute break, court will start again at around 11:30, and it'll go on till around 12:30. From 12:30 to 2 o'clock, they normally have lunch. So that's when anytime they have a break, they tend to lock the courtroom. So you're not allowed to stay in the courtroom during that time because nobody is in the courtroom. You can leave your stuff in there, but once you leave, they lock the doors. You're not allowed back in until the break is done. So then court will resume again at around 2 o'clock. Sometimes they will have a little bit of a break at around 3 or 3:15. It just really depends on how the afternoon goes. Sometimes it's 15 minutes, sometimes it's 10. It just depends on the judge and the clerks. So then court will normally end at around 4 o'clock each day. Sometimes it can go a little bit longer. It just depends on what's happening that day in court. If you're trying to just finish something up so that you can move your case along for the next day, sometimes it'll go a little bit after 4, but not normally. Times may be very too extended. So yeah, so like this is the last point, those times may be varied or extended to accommodate witnesses. So again, so sometimes they'll kind of be a little bit flexible with the sitting schedule, but most of the time they try to stick as close to that sitting schedule as possible. Next slide. So McKenzie friend, sorry, just give me 1 second. I can't see part of the slide here. There we go. So what is a McKenzie friend? A McKenzie friend is a support person who sits alongside someone appearing in court without a lawyer, or a self-represented litigant. The role is to provide practical and emotional support during the court process by helping to keep the self-represented litigant organized, calm, and focused. Anyone can act as a McKenzie friend, but generally it is a trusted family member or friend, or ultimately their presence in the courtroom is allowed only at a judge's discretion. So normally, sometimes you need to get special permission from a judge. Usually a judge is not going to be like, absolutely not, no way, you can't have this person sit with you. Most of the time, the judge is going to be very accommodating about that. If a judge gives permission, a McKenzie friend can sit at the front of the courtroom and take notes, organize documents, make quiet suggestions to the litigant, provide emotional support, pay attention to the courtroom discussion, and do any tasks approved by the judge. Mackenzie Friends may do all or just some of the above. But above all, it is important to decide on their roles and your expectations beforehand. So if you do have a Mackenzie friend, form a game plan with them. Let them know what kind of needs you need during each day in court. Have them understand their role, and also let the judge know what their role will be. The most important thing to keep in mind is that a Mackenzie friend is there as a support person, not to take the place of a lawyer. They are not able to give legal advice or speak directly to the court, except in very rare cases where a judge deems it appropriate. Even in cases where language comprehension is an issue, each circumstance is judged on a case-by-case basis. So a little fun fact, the Law Society and the courts, they're starting to open up, basically extend who someone can bring as a support person to court. If you ever go onto the Law Society's website, they have something called the Innovation Sandbox. You will notice that there's non-lawyers who are now providing legal services. So these are people who have gone through a very regimented application process and have been vetted, that can help self-represented litigants with their case. So someone like a paralegal, they can be given special permission to be in court with a self-represented litigant, which does help in some cases. It helps with, being able to provide that legal support, help the person keep focused, but because they have that legal experience, they can properly and help interpret a lot better than what a friend or family member would when it comes to, what a judge says. If there's a lawyer on the other side, what the lawyer is saying, what discussions are being had, just the rundown of the court structure in general. So it does help with people who don't have a lawyer to represent them. They will still get that legal support. It won't be a lawyer, but they'll still get that legal support that can kind of help them keep their case moving forward. Next slide. Okay. What if I need an interpreter for my court hearing? So in provincial court, they will provide you with an interpreter or a person to communicate with you in sign language if there is a hearing impairment. So provincial court, in criminal matters, they tend to be a lot more, I guess I'll say fluid when it comes to that. Like they will help provide an interpreter for you. Supreme Court, it's a lot different. In Supreme Court, you have to find your own interpreter. They don't have any court order or court appointed interpreters. You have to hire one yourself, or, if you can't hire one, sometimes they'll let you have a friend who can help interpret for you. It's a discussion with the judge, essentially. I've seen it before. I actually sat in on a trial where they weren't a court certified interpreter, but it was the only interpreter that could be found. So basically what the judge did in that moment was just, after understanding the circumstances, the judge basically, what I'll say is swear them in as a court appointed interpreter. So provincial court is a lot more lenient. Criminal matters, I believe they will provide one for you. Supreme Court family, unfortunately, you have to find your own. So if you need an interpreter, advise the registry as soon as possible. So there are links that you can click on to help find an interpreter. So I've used a few of these before. Mosaic, they're really good. They do, if anybody here ever has legal aid and needs an interpreter, Mosaic is really good at using legal aid funding to find you an interpreter. Diversity is also really good. I've used them before as well on files. They do have a big roster of interpreters, and they can most of the time find somebody quickly if you need someone quickly. Next slide. Okay, so consider using duty counsel. So family duty counsel services are intended to assist people with lower incomes who are representing themselves in court. They can provide advice about parenting time or contact, guardianship, or parenting times twice, child support, spousal support, property with limited advice, tentative settlement agreements, child protection, and court procedures. With duty counsel, the way that they give advice, it's kind of what I'll call a la carte. So they can't give you advice on everything. They usually will kind of give you advice based on what you're presenting with them that day. So it's kind of like more face value type advice. Next slide. So what is an expert witness? So if you saw earlier, we did have the little list of, you know, what kind of deadlines you need to be aware of. And I had said that some of those may not apply to you. So if you had seen in that slide, it did talk about expert witnesses and when to submit your expert witness reports or just having the discussion about expert witnesses. So not everybody needs an expert witness. It's a really case-by-case situation. So an expert witness, in order to act as an expert, the court must accept that the witness has acquired special knowledge through study or experience on the subject at issue. Further, the individual must be unbiased or appear unbiased, and appear unbiased, not or. The expert cannot appear to favor one side or the other. When considering if someone can act as an expert witness, the court may ask, have they given expert evidence before? Do they have an degree or certificate? Do they have professional qualifications? Are they a member of a professional association related to the proposed evidence? Have they attended additional courses and seminars on the subject? Have they taught about that subject? Have they kept up with the changes in the field? How long have they been involved with the subject at issue? How long have they worked in that field of issue? It is not necessary for an expert to satisfy everything listed above. However, the judge must be satisfied that the witness has acquired special knowledge to help the court. So you can find the rule on expert witnesses in the Supreme Court Family Law Rules. It's a Rule 13-2, which goes over who is what expert witness, what is the procedure to obtain an expert witness. So as I mentioned, not everybody needs an expert witness at their trial or in their case. So some examples of an expert witness might be for anybody who has a court case involving children. You may have heard about this type of report before. It's called a Section 211 report. Sometimes parties will get a Section 211 report. What that report is basically it's giving the courts, lawyers, any party to the file or the court case, basically a whole background of the family. So Section 211 report, they will interview both parents. They will interview the children. They will observe the children with each parent. They will also interview what we call collateral witnesses, so joint witnesses. So other family members, they'll probably want to interview teachers, you know, any person who is involved in the children's lives. So the Section 211 report, it gives a history of the family, the history of the two parties, their own childhoods, how they grew up. Basically, it's like understanding how the whole family got to where they are currently. So a Section 211 report writer has to be an experienced, usually it's an experienced psychiatrist or psychologist. If you have one in your case, you would ask them to be an expert witness. If you are trying to prove something based on that Section 211 report that you received, sometimes it's challenging it. Sometimes it's like to help get a better understanding of why that report writer kind of gave that type of report. Another type of expert witness could be an appraisal or appraiser. So if you own a property and you get appraised, but the other party doesn't agree with the value of that property, you might call that expert witness because you want to show this is why the property is worth what it is. But the other party has also the opportunity to, also question that expert. Another type of expert witness might be a forensic accountant. So sometimes one is needed if somebody's got really intense assets, or if they have a business. And sometimes, like if the business itself, like the financial statements aren't adding up, you get a forensic accountant to kind of like really look deep into the company's finances. So those are just some examples of what type of expert witness you would see typically in a trial. Next slide. Legal advice. So the judge cannot give legal advice to litigants who who are not represented by counsel. The judge must remain an impartial adjudicator of the issues. Each party is responsible for obtaining the legal advice that they need. So I have seen it where one party was a self-represented litigant and the other party did have a lawyer. So the judge cannot give any kind of legal advice. Sometimes what a judge will do, from what I have seen, is they'll try their best to help guide the one party who doesn't have a lawyer. And it's not being unfair to the person who has a lawyer. It's just, if you're a self-represented litigant, chances are you didn't go to law school. Chances are being a lawyer was never something you wanted to do, but you found yourself in a situation where you had to be your own lawyer. So a judge might sometimes try their best to give a little bit of guidance, try to steer them in the right direction, but they can't give any legal advice. So they have to be very careful what they're saying. Judges do their best to be impartial to both parties, because the whole point is that they're there to just hear both sides, question both sides, and see, which party has a stronger position. So position is like, who has like the stronger, what I call stronger story. Next slide. Okay, so evidence. So there are two types of evidence that can be used at trial. Physical documents such as emails, text messages, financial documents. The other one is oral testimony from witnesses. So a witness can be the claimant and the respondent. They're technically witnesses, and any other witnesses that would help support your case. For physical evidence, you need to prepare something called a book of documents. A book of documents is all the physical evidence that you plan on relying on during trial. For a book of documents, so sometimes you might have something called a common book of documents. So that's when you work with the opposing party or lawyer, and the two of you come together with a giant index of both parties' evidence that they plan on relying on. Sometimes, if you have a common book of documents, they'll kind of divide and conquer the work. So they might say, okay, you make 2 copies, we're going to make 2 copies. Or sometimes they're like, we'll make 3 copies, you make your own binder, but we use the exact same index. Other times, if you can't agree on what's going to go in that book of documents, then you would have your own separate book of documents. So one might be called the claimant's book of documents, and the other one might be called the respondent's book of documents. If you are creating your own, you have to have 4 copies of your book of documents. So one is for you, one is for the other party or the lawyer, one is for the clerk. So the person, you'll see there's always a person that sits kind of in front of the judge. So that's the clerk or registrar. So one for them, and then one for the witnesses. So anytime a witness goes into the witness stand, you would hand them the book of documents if you're trying to get them to identify something specific. So depending on the judge, they will either enter each document as an exhibit independently or enter the book of documents as a whole. Sometimes a document can be an exhibit if either party agrees on the judge's discretion or if a witness testifies to it. So what I have seen is it depends on the volume of the book, the judge, and just how things are going in court. So one trial I sat in on, the one party wanted to individually, every document wanted each one to be its own exhibit. The judge felt it wasn't necessary. He said normally that he liked to just take the whole book of documents and be like exhibit A or exhibit 1. And then from there, throughout the trial, when they go through each document, the judge would decide, okay, well, I'm going to take this one out. This is not relevant, or, keep it in there. So in this case, the judge just kind of said, okay, fine, we'll just do each one individually. So it's up to the judge's discretion how they're going to enter those exhibits. Sorry, just looking at my notes here. Okay, next slide. So general tips for appearing at the trial. So how you dress. Dress business casual. Dress like you're going to a job interview. Don't wear ripped jeans. Don't wear anything with provocative graphics or wording on it. When I say that, like if a shirt with a sort of provocative slogan on it. If anyone knows, an example would be the clothing company French Connection UK. Normally the shirts say FC UK. Don't wear that shirt. Look at the judge from time to time when giving your evidence or when asking questions to the other witnesses. If they are busy writing notes, slow down or wait for them to finish writing. That way you know that they are listening to what's happening. When you refer to documents in your book of documents or in the trial brief, wait for the judge to flip to that page in the binder before continuing with explaining the significance of that document. I have seen it where sometimes judges do kind of get a little frustrated when even if the lawyer goes way too quickly and is just flipping through, page to page. It frustrates the judge. So, do your best at kind of looking at what the judge is doing. So if you see the judge is still flipping to get to that page, just wait till the judge is there. Lock eyes with the judge and be like, so justice, can I proceed? And the judge will tell you. It's a good idea to telegraph what topic you will be talking about next to help the judge keep track of the evidence being presented. For example, I'm now going to talk about the parenting issues. I'm now going to talk about the circumstances of our separation. So some judges, a good chunk of judges, do like to be walked through everything. It makes it easier for them to follow along, because chances are the judge you get is the first time they're going to actually see you, know your case, right? And also see the evidence. So taking your time and just explaining exactly what you're doing. The only way I can that I can describe it as, if you ever watch TV, like NCIS, or anytime there's like a hostage situation, they're like, I'm now going to do this. I'm now going to put my hand here. I'm now going to grab this item here. So it's basically like that. Like it's I'm now going to go to tab 5, page 7, paragraph number 6. So basically walking them through. I'm now going to discuss the parenting time, between me and the respondent. So just basically just do your best to describe what you're going to do and what you're going to say. When speaking to a judge, refer to them as justice. So it used to be based on gender. So if it was a male judge, you would say my lord, or if it was a female judge, you'd say my lady, my ladyship, my lordship. They don't use that anymore. So now it's, you basically just say, my justice, or you say the judge's name. I'll make a note. I do have a little write-up of how you address, it's called forms of address. So how you address each type of judge in court, because there's many different types. There's Chief Justice, there is in provincial court, there's judge, you say judge or your honor. With with a registrar, so if you're ever doing like a registrar's appearance, same thing, use you know, your honor. So I'll make a note to include that when we send out the recording, the forms of address, because those are really, really helpful. You know, you know, if you don't know how to address somebody, it makes it more nerve-wracking and you can fumble. I've fumbled many times. So forms of address. Okay. Sorry, where am I at now? Stand up when the judge enters or exits the room, and don't sit down until the judge sits down or has left the room. So basically, as soon as the judge walks into the room and the registrar says like all rise and says the judge's name, that's when you stand up, and you stay standing until the judge sits down. So as soon as the judge sits down, you all sit down too. Anytime you need to leave the courtroom, so this is more for chambers, because in trial you're going to be on most of the time. So you're not going to halfway through be like, I need to go to the bathroom. But if you are in chambers and you're sitting in a room with many people who have different types of court applications or court hearings happening, and you need to leave the room when it's not your turn to speak, you would simply stand up, you go to the door, you turn around, and then you bow, and then you leave. But that's in chambers. Stand up whenever you are talking, either when you're talking to the judge or asking questions of a witness, and sit down whenever the party or their lawyer is talking. You should not both be standing at the same time. The other party or their lawyer is in the middle of saying something to the judge, and the judge asks you a question, stand up to give your answer and then sit back down. So what that is kind of it's supposed to be like a mutual respect. So if the other party, if it's their turn to, you know, to examine a witness, they're the ones standing up. When it's your turn to examine a witness, you're the one standing up. If you're objecting to something, that's when you stand up to object to that matter, and then you sit back down right after. Or anytime a judge is asking questions. So if the judge stops talking to the party and then asks you a question, you stand up and then sit back down. Okay. Next slide. So first day of trial. So I wanted to kind of highlight what a first day of trial can look like. I feel like this is one of the most important days of the trial. It sets the tone of your trial. So your first day of trial, usually the first day of trial is meant to lay the foundation for the rest of the trial. So what does that mean? So what that means is it goes over any preliminary matters that you might have. So any last minute applications that you want the judge to order on, such as disputes on witnesses, which I have seen. I have seen it where both one party wanted a certain type of witness to appear. The other party didn't agree that that witness should appear. They felt it was not in the best interest of that witness, but also it wasn't necessary to the case. So what they did was they had what we call a mini application. So they quickly get that issue dealt with, and the judge will make an order right then and there to be like, yes, I want that witness to appear, or no, I'm not going to grant that order, and that witness is not appearing. So in this case that I saw, there was an issue with a witness appearing. The judge did grant that witness should not appear. So that was a mini application that happened before trial. Any other preliminary matters that you feel the judge should know? any disputes with certain evidence. So if you have your book of documents, or even if there was a common book of documents and there was something in there that one party is like, no, that is not even relevant to what we are on trial for, that might be a mini application again. It might be, you know, this is not needed. This is not part of the, like, this has nothing to do with the trial. The judge might decide, well, he'll hear, or the judge will hear both parties' positions or stories of why they think that either it is that should be part of the trial or should not be part of the trial. Then the judge will quickly make an order. I have seen when, you know, for other I'm having troubles talking today. Preliminary, so quite the word, matters. So one case I helped with I helped a self-rep was there actually was some issues with the lawyer and the opposing party. And the big issue was they weren't disclosing documents, and they hadn't disclosed any documents until a few days before trial. It was very frustrating. So I told the client to talk to the judge at the start of the hearing. You know, either the judge is going to agree with you or not agree with you, but let that judge know that, hey, I only got these documents like 3 days before trial. I hadn't seen them before that. I didn't even know what the position was until 3 days ago. And the judge will, you know, kind of figure out how things should go from here on out with that issue. In that case, the judge felt a little bit compelled to, it had to be included, but the judge did take notes that that was going to be an issue, and they just kind of dealt with it as when it came up again. So it wasn't dismissed, but the judge really considered that part, which did set the tone in the client's favor. Actually, it did help set the tone for that trial. So the judge was aware that the other party and the lawyer were not, some of the things they were doing was just, all it's called, unsavory. And the judge took note of that, and it worked out better for my client. Another thing that they'll do is kind of go over the schedule of the trial. So going over the schedule, so, you know, how long opening statements might take. So if the judge asks, what's your time estimate? They're asking you, how long is it going to take you to do your opening statement? So time estimates on statements, witness testimonies, what day will or should the witness testify on, how long each testimony will take. So that includes direct examination, cross-examination, and one thing we forgot to include in here was what's called redirect. So the judge wants to know on what day is what witness coming. So they kind of set the tone and set the schedule around the witnesses. So there are some witnesses who can only come on a specific day. So they'll be like, okay, fine, that witness is coming on this specific day because it's the only day they can come. So sometimes your trial can get flipped around. So normally it's the claimant that goes first, then it's the respondent that goes after. So it's kind of broken into a few days. So the claimant is supposed to go, you know, for the first few days with their witnesses, then the respondent will go, and then with their witnesses. But sometimes based on witness availability and schedules, they work with what they can have. So if you ever have a witness who lives overseas and they're going to be a witness, but they have to appear by video, which again, that's a trial I did sit in on from my office. One of the issues was one of the witnesses lived in a different country and can only get on at a certain time, and it had to be done by video. So they basically set the schedule around this witness so that the witness could be present. And then time estimates for closing submissions. Next slide. So opening statement, what is that? So an opening statement is basically a summary of your case, and that can include the facts of your case, what orders you are seeking or what orders are in dispute, your position or story, on each order you are seeking or disputing, what evidence you expect to provide that shows why such an order is appropriate or not appropriate. For drafting an opening statement, you can either create what's called a summary brief or use point form notes. So a summary brief is like basically kind of like an affidavit or like a notice of application. I can find an example that I think we can include. I believe there is on the National Self-Represented Litigant projects. They do have a lot of resources. So we will be sharing some of those resources with you. They do have a setup of what an opening statement can look like, but it's also a good document to kind of help you when you're preparing for an opening statement. But essentially, it's kind of broken down. So it's opening statement. You kind of have it, make it look like what a typical top of a court document looks like, where it has the, the court action number, the registry that the file is at. So it'd be like, court action number E123456, court location or court registry, Vancouver. And then I'll have in the Supreme Court, the claimant's name, the respondent's name, and then it would be like opening submissions. And then from there, you can break it down into categories. So you can be like background of the party's relationship, and you want to keep that factual. Then you would have, something like talking about orders. So orders in dispute or orders you are seeking. And then you would write out what type of orders you want. And then, claimant's position or, claimant's side or story. And then you'd write out underneath that what your position is, why you want those orders. In that same area, you could talk about like, the evidence will show, whatever the evidence in your case will show. So, if you are saying the claimant is seeking primary care of the children, the respondent has been in and out of the children's lives, the respondent has not been taking proper care of the children, not being really involved in the children's life, the claimant has been basically the primary caregiver, and then the evidence will show, and you would list out what evidence you have that's going to back you up on why you should have primary care of the children. So if you do some kind of summary brief and you want to share it with the judge, which some people do, a lot of lawyers do it. Some judges actually do like to have those because they kind of will look back at it occasionally. So if you do share an opening statement with the judge, you do have to also give one to the opposing party as well. So just keep note of that. If you're going to share something with the judge, you have to share it with the other party. You don't have to create an opening, like a physical brief if you don't want to. You can also do point form notes, but an opening statement does kind of, if you write out an opening statement, it helps you. It helps you remember what you're doing. It helps keep you on track. So, if you're not sharing an opening statement, that's fine, but do have some kind of opening statement to kind of help you stay on track when you're doing your trial. When you are talking or presenting your opening statement, speak clearly, slowly, and particularly if you are reading off of your statement, which you can, right? You can just be like, Your Honor, is it okay if I just read directly from here and look at it? That's fine. Just occasionally make eye contact with the judge. Next slide. So testimony during a trial. So as I mentioned before, typically the claimant will be the party to first present their case and testify. The claimant will then call their witnesses. It is the responsibility of each party to ensure that all witnesses that want to testify are available and at the courtroom at the correct time. Witnesses cannot be sitting in the courtroom. So anytime you have, so when you do have a witness that is going to be going to be testifying that day, they're not allowed in the courtroom. They're only allowed to show up at their exact time. And the only time they're entering that courtroom is to sit on the witness stand. They're not allowed to sit in the gallery. So keep note of that. Sometimes a witness may need to be subpoenaed or forced to testify. Unfortunately, it does happen. Sometimes people will want to be subpoenaed, and it can be because of work. So I have seen it where someone was like, I can't get the time off. I want to be a witness, but I can't get the time off. So they get subpoenaed, because if they get subpoenaed and send it to their employer, to my knowledge, the employer has to abide by that. But I can also, I'll make a note to, because I do not want to tell you one thing and then you go and try to do it and a judge is like, what? No. Or the employer's like, what? No. Subpoenas. Before each witness testifies, they must be sworn in or affirmed. So this means they are, before they even get questioned, they have to make an oath that they're going to tell the truth. The claimant or the lawyer can begin to question them about the matters at issue. So when they get onto the witness stand, you know, sworn in is usually you're putting your hand over a, you know, like some kind of like religious symbol. So some people it's a Bible, some people it's a Quran, you know, it's just based on what your religious background is. If you are religious, other people just get affirmed in. So they would just, you know, like that. So there are, sorry, I should say 3 types of questions for examination. So there's direct examination, where one party is questioning their supporting witnesses. So if the claimant had a lawyer, the lawyer would be questioning the claimant on the stand. For a claimant, and they're supporting witnesses. So if they did have a lawyer, the lawyer would be questioning the supporting witnesses. If there is no lawyer involved, and the claimant has to do testimony, sometimes, and what I have seen is they will let the claimant kind of have notes and just kind of speak and just share their story. And then the claimant can then examine or question their supporting witnesses. Cross-examination is where one party is questioning the other party's supporting witnesses. So for a claimant, so it would be the respondent's lawyer that would be questioning the claimant. It would also be the lawyer, or if the respondent didn't have a lawyer, it'd be the respondent directly questioning the claimant. And then the respondent would be directly questioning the supporting witnesses of the claimant. Basically, a cross-examination is a way to kind of poke holes at a testimony. So if one party is testifying to something that it's like, oh, actually, that didn't really happen, or that wasn't on that date, this other thing happened, they would then start poking holes at that testimony. Redirect examination is where the original party can ask more questions to their supporting witnesses. So let's pretend the claimant was doing their testimony and they had a lawyer, and the lawyer was, doing their direct examination on the claimant. Then it was the respondent's turn to do what's called the cross-examination on the claimant. So the respondent does it and is poking holes at what the claimant is saying. The lawyer of the claimant could do a redirect. So that means anything that if there's any holes poked into the testimony, the lawyer can then go in and get more clarification on the poked holes, if that makes sense. So it's the same thing like so if it doesn't have to be a lawyer that does it. So if you're self-represented, you can do a redirect of your own witnesses if you need to. When organizing your evidence for examinations, try to do it chronologically and have a list of key dates and events to remind yourself of to address them for each witnesses. So it's helpful to have a list of all the questions that you want to either that you're going to testify to, if you don't have a lawyer, or your lawyer will have a list of questions they're going to have you testify to. Same with your witnesses, you're going to have questions for them as well for them to testify to. So it's always helpful to keep everything in chronological order. Or, you know, if you have a witness for a very specific thing, you would ask questions based on that specific thing. Next slide. Excuse me. Either party is entitled to testify whether or not they have a lawyer. So again, so if you don't have a lawyer and you're self-represented, you are entitled to testify. As I mentioned before, if you don't have a lawyer, let's say you're the claimant, you don't have a lawyer, but you need to testify, the judge can help give direction on how that'll be done. So the one case that I was helping on, it was with my client who was self-represented. What the judge did was just let them go on the stand and just say their story. So they had written up all the points they wanted to get across, and then they just said it out loud. And sometimes the judge might interject or interrupt and might ask a question. And sometimes when a judge stops to ask a question, they need some clarification for themselves to kind of help them better understand. The party testifying should have their chronology notes with them if they testify. Sometimes a judge will allow a self-represented party, as I've said, simply just tell their story, and from there the judge may step in and ask some questions. The judge and the other party will be entitled to look at any paper that a witness is looking at while on the witness stand. So ensure that any notes do not include things that the other side and the judge are not entitled to know. So basically just make sure that you're prepared for everyone to see what you need the witness to see. So that's when that book of documents would come in. Because if you're trying to point to a specific document that you need that witness to acknowledge or confirm, the judge also and the other party also need to see that same document. Only admissible evidence can be provided by a witness. So what that means is, and this happened in the case that I was helping with, there was reports from the children's school. And so what should have happened was, it should have been the person who wrote that report should have been the one testifying to, but they didn't, they couldn't testify to it. So unfortunately it wasn't allowed. And I'm not saying that would not happen in every case, but in this case it wasn't allowed. So always, anytime you're going to bring some kind of document and it's attached to a party, so it's better to have it like connected to the witness. So your witness can help authenticate that document, so they can confirm that, yes, this is real. Yes, I wrote that document. Yes, this is why I wrote that document. This is what it was about. So that's what admissible is that it's allowed into the trial. After direct examination, the other party or their lawyer may cross-examine the witness. Everyone who testifies should be expected to be cross-examined. So like I said, so cross-examine is when the other party can then, you know, question those supporting witnesses. So if the respondent can question the supporting witnesses of the claimant, and that's when they would start trying to poke holes in what that person has been testifying to. After direct, if a new matter arises during cross-examination, the original party may re-examine the witness on that issue during a redirect examination. So again, so there's some things coming up during testimony, they're poking holes. That's when you can jump in and be like, okay, I want to redirect because I want to see if the witness can clarify it. But you don't say it like that. Next slide. The judge is entitled to consider all the evidence, and so can consider answers on direct and cross-examination and redirect examination. So basically the judge is going to be looking at everything as a whole. So the evidence, book of documents, and the testimony. The procedure continues for each witness until the party has presented all of the evidence in support of their claim. The judge cannot consider affidavit evidence at trial except in special circumstances and with a specific ruling permitting such evidence. So if you're trying to use actual affidavits, that's when that would be something that you could do during the preliminary part of a trial. Sometimes you need a court order. So if you're trying to put in something, like if you're trying to put in an affidavit, that's when you can take those exhibits from that affidavit and put it into your book of documents. If the parties conducted pretrial examinations for discovery, or if there are transcripts from a prior trial, the judge cannot consider the evidence in them unless they are presented at trial, either by being read into the court record or when a witness is referred to the transcript. The judge can only consider the portion which is read into the court record or shown to the witness. So if you have transcripts, so for discoveries, so as I mentioned before, do an examination for discovery, you can get transcripts from that discovery. So if the claimant's being discovered, it's only the respondent that can use that transcript from the claimant and bring it to their attention during trial. Same thing if the respondent has been examined, the claimant can use that transcript from that trial. And again, bring it to their attention. So transcripts, I don't have too much experience with them. I have seen it be used. I have seen it be brought to the attention. If anybody does have questions about that, specifically about how one uses transcripts, I can look into that a little bit more and give a better answer to that. So I'm just going to put a little note here, transcripts. So if anyone has specific related to number 15 on the slide, any specific questions related to that, just let us know and then I can search that answer for you. Okay, next slide. When the claimant finishes their testimony, the respondent may make an opening statement. Sometimes the respondent does not bother making an opening statement, such as when the questions in cross-examination have demonstrated the respondent's position. So I've seen it more, I haven't really seen this. I have seen it more when both parties do openings. Just because sometimes whatever the claimant says in their opening doesn't always reflect in what the respondent feels their opening should be and what their positions are. So they don't have to, but every time I've sat in on a trial, the respondent has also done their own opening statement. After making an opening statement or choosing not to do so, the respondent will then follow the same procedures with all the respondent's witnesses as already described regarding the claimant's witnesses, except that the respondent will be leading his or her direct evidence and the claimant may be the one cross-examining. Where there is more than one respondent, each respondent can make an opening statement and follow with his or her witnesses. So when they say more than one respondent, sometimes there are two respondents to an action. Sometimes there is, so you can have even more respondents than two respondents in one action. So if you ever see it there in the notice of family claim, there's a claimant and a respondent. If there's a counterclaim done, you can actually add an additional respondent to that counterclaim, and they're called a respondent by counterclaim. So that's what number 18 is referring to. So if there's more than one respondent. Next slide.
Jen, did you want to take a quick break before there's a couple slides left?
Actually, yeah, let's take like I need to get some water.
Yeah, let's take about a 10-minute break and then we'll come back. It's 6:35, so we'll come back at 6:45.
Yep, sounds good.
Okay, perfect. Thank
Okay.
you, everybody. Okay, hi everybody. It's 6:45, so if you want to get back and we'll get started again, just get to the next slide here and Jennifer will take over.
Okay. Welcome back, everybody. I hope you had a good 10-minute break. I quickly ate a snack, so I feel better. So important rules of evidence. Unless the witness is accepted by the court as an expert witness, they must state only what they say, heard, did, or said. So they can't give any type of opinion or interpret anything. So an example would be, talking about if there's children involved and talking about their mental state, or their, anything that could come off as like psychology. So like trying to give an opinion on their psychological state. They can't do that because they are not an expert in psychology. Unless they're there specifically to be an expert on, child psychology, they can't do that. Testimony and documents cannot be admitted if they consist of irrelevant information, dates, either the day or the month or season, or else the information would be rejected as irrelevant. So again, that's where sometimes you can have that preliminary matter heard about specific types of documents being one party trying to submit a document as evidence. That's when you would try to deal it during that preliminary matter or at the first day of trial, if it's not relevant to the case at all. So let me see if I can think of an example at the top of my head. If the trial is mainly about children and parenting time, and then one party wants to bring up the valuation of a property for some reason. If the trial is specifically, the issues are only related to, parenting time, parental responsibilities, and maybe dealing with child support, property might not be relevant in this situation. So again, that's just an example. Each case is different and no case is black and white. Testimony may not contain argument. So this one, it's a little bit gray to try to find an exact example of what can be argument. I might have to come back to an example of that later on. It is not acceptable for a witness to quote what another person has said. That's hearsay. So if that witness was not specifically there for a certain situation that took place, that's hearsay. So I can think of an example, like, sometimes you might see it in an affidavit, where the claimant says that they heard that the respondent started a fight at a sporting event and the children were there. If the claimant wasn't there, that's hearsay. Testimony may not contain speculation. So again, it's if you're guessing, if you're like, I think this is what happened. I think that they, this is what was going on in that person's mind. Well, no, you don't know, because you're not in that person's mind and you weren't there for that situation. So it's, again, that's what speculating is. Do not seek to include in evidence long exhibits like long email chains or diary notes. So if you're trying to submit an email conversation and it winds up being 50 pages long, a judge isn't going to like that. Judge doesn't want to sit there and have to go through the whole 50 pages, especially when you're on already a very strict time schedule for trial. Another example would be, like a diary. I actually did a trial we had. They were trying to use diary, the claimant's full diary, and it wasn't relevant. So that was an issue right there. But also it was a big book, right? It wasn't allowed. Expert evidence such as opinions of doctors can be admitted at trial only if the party seeking to provide the evidence has given the necessary notice to the other side. So sometimes if medical, like if there's like, medical issues that come up that could factor in, like for parenting time, for example, if somebody is seeing a doctor for, very specific type of reasons, sometimes it can be for, mental health reasons. So if mental health is, affecting how they parent a child and they're regularly seeing a doctor, if they want to get that doctor's opinion, it could possibly be, and again, I have to be very careful how I say this because I'm not a lawyer. So sharing this, like saying this type of information, it's very, I have to be very careful. If people do have questions on number 7, I can look into it. If you want to know more about like expert witnesses, what can be admitted, I can definitely look into that more for you and give you an answer to that or feedback on that. Next slide.
I just wanted to touch base on the one that we were looking for a little bit more information on.
Yes.
Testimony must not contain argument. So I can just provide a quick example for you.
Perfect.
So it's not argument to say something like, I think it is unfair that, or to include any kind of rhetorical questions like, why should I do this when the other party? So just kind of an example of like when you're arguing what the other party should or shouldn't do, that's not something that goes in your testimony.
Perfect. Thank you so much. I appreciate that. Yeah. Next slide. Objections. So I mentioned this earlier. So, when I was talking about when you stand up, and when you stand up, if you were to object something. So if at any time during the course of the trial, you believe that the other party is asking a question that is irrelevant to the case or admissible for some other legal reason, you should stand immediately and state politely that you object to the question. So that's when you would stand up and be like, Justice, I object to this questioning. You will have the chance to explain why you say the question is not proper. The other side will have a chance to explain why the question should be permitted. You will have a chance to reply if anything new was raised in the other side's argument on the objection. Usually the trial judge can decide quickly whether or not to uphold that objection and will make the ruling right after the submissions about the objection. Once the trial judge has made the ruling about if the question must be answered, the examination, the witness can continue. So that's when you kind of have little sidebars, right? So they might stop the questioning right then and there if you object. The lawyer or the other side might have a chance to ask why. The judge might ask why, and you have to say why you object to that question. Because sometimes it could be like objection, what is the relevance to it? The other party would have to explain why it is relevant, why they need to ask that question. Judges will try their best to limit how much time that objection can be, because if they don't, then it could just snowball from there. But a judge can quickly decide, okay, yeah, I agree. Objected, like I'm gonna uphold that objection. You can't answer that question. I'd be like, actually, no, it is relevant. So I want them to answer the question. Next slide. Submissions or arguments or closing statements. So usually you'll hear the words closing statement, opening submission, closing submission. They kind of, you'll hear people flip-flop between it. After all the parties have like essentially closed their case, so once all the testimonies are done, that's when they would close their case. They have finished presenting their evidence. The claimant will make their submissions or arguments or closing statement. The respondent will then make their submissions or closing statement, and the claimant may reply to any new matters raised in the respondent's submissions. So sometimes it might not happen right away, doing closing submissions, statements, arguments. Sometimes So let's say you have a 5-day trial. Sometimes you might use up all the 5 days, but you haven't been able to do any closings. A judge might make a ruling about how one will do a closing. So it could be you have to come back at another time, or it could be, I want you to both do closing arguments and then send them to me. And then from there, the judge might then take those closing arguments, look at all the evidence, look at all the all their notes, everything that they have obtained from that trial, and then make their judgment. Submissions should consist of describing the evidence which the party says the judge should accept and why the law and facts show that the judge should make that requested order. Go over the main points of the evidence you presented, point out the problems with the other party's evidence, say how the law applies to your situation. You cannot bring up any new points in your closing statement. So once you have closed your case, you can't bring up anything new. So basically you can think of a closing statement, argument, submission as like your conclusion. If any of you have ever written an essay and then you have to like tie it all in together with your conclusion, it's like your closing. Summarizing this, like summarizing the whole case and then tying it in. Nobody likes doing conclusions. I hate doing conclusions. Next slide. All right, so that brings us to the end of the presentation. I appreciate everybody tonight coming in, and I do apologize that it was me that had to do the presentation tonight. We did, as I mentioned earlier, we did have a trial lawyer who was going to be doing tonight's presentation, but unfortunately they got very ill. So it was me and Rachel putting it all together for you all. So now we can go into questions, and there is a book that I will show you. It's from the National Self-Represented Litigant Project site. This is a really good resource. I have actually shared it with some clients that I coach, just because it even for me, it helps explain things, because the books that I have at my office, sometimes I look at them and I'm like, am I dumb? How come I'm having a hard time understanding this? But I found that this one, it kind of helps plainly explain certain aspects of a trial. So let's get into some questions.
Okay, so one of the first ones is examination for discovery also called disclosure? So I think those are going to be yes and no.
Yeah, that's what I was going to say too. Yes and no. So sort of, right? So usually during examination for discovery, that's when you're trying to get the questions that you like, anything that you want the other party to say, you're trying to get them to say it during that during the discoveries. So sometimes if the party brings up a document, and I don't know if Rachel, if you have any examples in your head, like how one party would, mention, I don't know, an immigration matter, right? So they're like, oh, well, at the time I wasn't a resident in Canada. I wasn't here when, from what the claimant is saying, that's not true. I wasn't even here. And if they mention they have some kind of document, well, in the discovery, you can ask for them to later on give you that document. So it would be called a request. And they actually do, if you do a discovery and you get transcripts, there is a section in the transcripts that does say request made.
Yeah, so that's usually where, if there's a document that needs to be asked, then they'll list out in like an index for you each of the documents that need to be produced by the other side because they were brought up during this examination. But in like terms of what you're asking, it's not the same thing. Like one is an actual meeting that you get to ask questions to the other side. Disclosure is something you can request like at any point of your case. The next one here, oh, that one we've answered. So I know that you mentioned in regards to an expert witness about the like forensic accountant, and the person had asked about a CPA certified accountant. Can they be a expert?
I think it depends on the qualifications. Let
So
me jump to that rule. So, and it can't just be any kind, right? You, if you're trying to get a certified professional accountant or a CPA to be your expert, and they never done this before, and they're like, I literally, just do taxes and then go home. They might not be qualified to be an expert. Um, and it would depend on the other party if they would agree that, okay, yeah, maybe they're an expert, or if you're trying to make them be an expert in your trial, the judge might not qualify them. So it really, really depends. So I think I said that was 13.2. So 13.2 of the, of course, it didn't even go there. Jump to my rule. There we go. So rule 13.2 is the duty of an expert witness. If you go to rule, of course, when I 13.2, advice and certification. So there we go. So it's, yeah, so rule 13-2, duty of an expert witness. Advice and certification. If an expert is appointed under this part by one or more parties or by the court, the expert must, in any report he or she prepares under this part, certify that he or she is aware of the duty referred to in subrule 1, referred or has made the report in conformity with that duty, will, if called to give oral or written testimony, give that testimony in conformity with that duty. Right? That was really easy to understand. Yeah, everyone understood that one. So yeah, you kind of have to be careful about who you're going to use as an expert witness. Generally, the courts do want a certain type of criteria filled out. They're going to want their what they call a curriculum vitae, or which is a fancy word for resume. They're going to want to know their whole work history to show why they are an expert. So if this is something they haven't done before, being an expert witness, they're going to have to really show why they are an expert. If you are going to use an expert witness, you do want somebody who has been to court quite a few times, who does have that background and experience providing expert witness. So anyone who's looking to find an expert witness, when you're Googling certain types of experts, you do want it to be shown somehow, like whether it's on their website, whether when you interview them or you're in the hiring process, that they actually do have experience in court, because it makes it, the more experience they have, the easier it is to have them be qualified as an expert witness. So hopefully that answered the question.
I think it also depends too on the reason you're wanting like a CPA. Like there's like business valuations or like guideline income reports. Like there are specific people that are qualified as experts for those type of accountant reasons. So yeah, just depending on the reason that you need a CPA as well. Okay, so I think you did mention it, and you're going to also send out in our when we send out the recording is to how to address the judge in provincial court.
Yes.
And so I think we're going to include that with all the information in the recordings. Do you need an opening statement in provincial court? So we're just mainly dealing with Supreme Court with this trial information. So there might be different things that apply in provincial court, but in terms of Supreme Court, you do need the opening statement when you're going to trial. And then I think there was you wanted to mention about the subpoena as well.
Oh, yes.
If somebody needed to get out of the subpoena, or if your work kind of says no, the only way that you're able to kind of quote unquote get out of the subpoena is if you were contacting the person that issued the subpoena. So if it's the lawyer from the other party that issued you the subpoena, or the other party that directly, you'd need to contact that person for them to like reschedule the subpoena. But it's not something your work can say no to. You would need to just have the authorization from either the court itself or from the other party or their lawyer.
Rachel's the subpoena go-to.
Is an opening statement required for chambers hearings or more so just for trial?
Mainly for trial. I mean, and I'm sure I think this will be touched on next week. But I'll quickly. So with like regular chambers hearings, you do kind of want something written, like just even notes for yourself that kind of help explain why you're there. So some people will literally just read off their notice of application about the orders they're asking for, the factual basis, and what kind of law they're relying on. So I mean, for regular chambers, you don't need an opening statement really, but you can set yourself up with something similar if you want, just to help you keep, your thoughts and facts and everything you need to address in order.
Okay, next one. Orders of a judge regarding division of assets can take place at a JCC, or is it only during the trial? Believe that.
Where's that question? I thought I saw it earlier too. Oh, orders of a judge, division of assets can take place at a. So JCC, I mean, yes and no, because a JCC, the only time you can make orders is if the both of you agree. If you're consenting to that order being made. So if at the JCC you're talking, the judge is hearing both of you out, the judge kind of sees a judge is not a mediator, but sometimes some judges can help mediate during a JCC. And if there is a way to get the parties to agree on dividing assets at the JCC and both parties are in agreement, then a judge can order it. So sometimes, yes, you can have that happen at a JCC. But again, if one party's like, no, absolutely not, I ain't going anywhere, I'm not even going to talk about this subject, a judge, the JCC judge won't order it. So then it would be moved to trial.
Okay, I think there was a question about raising objection while the other lawyer is talking. So that's usually when you would bring up an objection if there's something that the other lawyer is saying that you object to. That would be when you would raise an objection. Oh, you mentioned that there was a book that you were going to share. That's from the National Self-Represented Litigants Project, right?
Oh, yeah. Here, should I share my screen quickly?
Sure.
Okay. Stop. Yes. So I'm on share. So it's this book here. It's I don't know if we can fit it in. We might have to send a link for this one because it's a pretty big book. But it's called the Family Law Handbook for Self-Represented Litigants. And it is a very helpful book. It's not targeted towards BC cases. It's kind of like a foundation for what a typical trial in most courtrooms across Canada will look like. But it is a very helpful book. It does go over opening and closing statements. As you can see, I was just trying to look for it. Yeah, so on page 122, 13.2 opening statements. And then here's the opening statement worksheet that can help you kind of set out your structure for your opening statement. And I think there is one for closing statements as well. No, clearly this just proved me wrong. So this book here, I think we'll probably just have to include a link because it's a very big book. And then you should be able to download it yourselves, but this book is pretty helpful. And it helps me explain to some of my clients, like in a more less chaotic way than how I'm talking right now. And not trying to use the legalese or trying to like how I was trying to read off the rules for you guys. And even I was like, I found this book to be very helpful to kind of help at least explain the structure of what trial and court look like. Okay, now stop sharing my screen.
We have a few minutes left if anybody has any last minute questions. Otherwise, I think we'll wrap up a little bit early. I'll just give it a minute to see if anybody has any other questions.
Okay. So I had someone send a question. How much does a book cost to book? So to book a trial, you're really only paying for the filing fees. So in Supreme Court, you're just paying the filing fees. So to book your trial, you're booking a notice of trial. And you're booking it based on the availability of the court and how many days you need. The other party does have to agree to those dates as well. You both have to be available and you both have to agree on it. Otherwise, you're not going to get your trial date. It's just going to like, they're going to reject the notice of trial. So you're not really paying for the courtroom itself. You're not paying for the judge to be there. You're just paying the filing fees to get that trial. So if let's say you manage to book a 5-day trial in Vancouver court on April, I'm just throwing a date out of my head here, like April 10th. The other party agrees to April 10th. You agree to April 10th. You want to book a 5-day trial on starting April 10th. You would file a notice of trial, and I believe the filing fee for that is $80. I could be wrong.
I think it's actually 200.
Is it 200? Okay, so I really misquoted that. So you're just basically paying for the filing fee, and then you're just kind of at the mercy of the court availability. So that's why the courts do that thing where I said on the earlier slides that showed, the timelines you need to abide by. And those ones specifically, which was about getting your trial brief, getting your TMC booked, making sure you have your trial record filed, and your trial certificate filed, because those 4 things in particular, they will bump you. They will strike you off their list, or as my boss likes to call it sometimes, limbo. You're just in limbo. So you want to avoid that. But so basically, yeah, so for like booking a room itself, getting a judge, you don't really need to, you're not really paying for that specifically.
I just confirmed with the court fees, it is 200 for a notice of trial.
There we go. 200 for a trial. What if the other party refuses to agree to a day for a trial or hearing? I think you would have to maybe go in on an application.
There have been instances where I have gone, you've basically given opportunity for the other party to agree to a trial date, and then potentially set one down unilaterally. But they are always able to say they're not available to it on the court hearing. So yeah, I believe that Jennifer would be correct in saying that it should be by application.
Yeah, so you basically want to go to a judge and be like, I'm trying to get a trial and they keep saying it's not available. So sometimes a judge can order that trial will happen. So I hope that answers the question about what happens if a party will refuse, because it is unfortunate that it happens. It's not uncommon for one party just to be completely unreasonable. It's very, very frustrating. So you always want to use court as your last resort. So if you can't for the life of you get one, then you would try to just go on what's called regular chambers. So trying to get in. So in Vancouver, regular chambers, I don't know if they're going to go over that next week, but regular chambers is usually Monday to Friday from 9:45 to 4 o'clock.
And there isn't necessarily a specific name of the application. Whenever you go in for a chambers application, it's just you're going for a chambers hearing. So that would always be using a notice of application, an affidavit. And our next session is going to be about applications next week, so they can go a little bit more in detail about that one. But yeah, the question for what is the application called? It's just bringing forward a chambers hearing. Okay, I think that's all the questions I have. If there was anything else that you got, Jennifer?
No, I think that's it.
I'm not sure I understand this last question. Something, I believe, an interim order.
Yeah, I'm not too sure.
I think that maybe like an application for interim order. All of the stuff about applications, they're going to go over next week. So just about our trials. Okay, yeah. So applications again for the questions that are just coming in. It's all going to be dealt with next week. So I think
Yeah.
for trial specific questions, I don't have anything else. So I think we'll wrap it up for tonight.
Yeah.
Okay, perfect.
All
Okay,
right.
thank you,
So
everybody.
thanks for coming by, and we'll see everybody next week. All right.